Michigan is a right-to-work state. We can work whatever way we feel is best for us in terms of whether or not we feel joining a union is in our best interest. Some people feel it is. Others don't believe it is. How can that be the case? Because we've been told that unions are the best thing for workers. Congressman Andy Levin has told me that unions are actually a human right. Each human needs union membership. Otherwise, they're not getting a fair shake. Their rights are being trampled upon despite the many laws in the books to protect workers, which are largely abided by in the vast majority of corporations. In fact, Democratic members of Congress, they have been fighting for their own employees to be unionized to protect their rights, ostensibly from abuse from their employers, which in this case are the actual members of Congress. Are they saying Congress is violating their employees' rights? Well, there's an interesting case right now. Because the supposition is that unions are absolutely fair. They're on guard to protect workers from employer abuse. Well, let's bring up this case in Michigan where a group of construction workers feel like their rights are being abused by not their bosses, but by their union. They're represented by the International Union of Operating Engineers, or IUOE. The workers are employed by Rieth-Riley Construction Company. The employees, well, they want out of the union. At least they want to depose some of their union leadership. Probably a better way to say it. They have that right, if they so choose, to vote out its union leaders. It's called a decertification vote. They tried that in 2020. However, an apparent union boss stepped in after the vote to decertify, but prior to the ballots being counted, and was able to invalidate the whole thing with something called blocking charges. They filed suit. The National Labor Relations Board stepped in to help to rule on the case and basically sided with the union that they were allowed to destroy hundreds of ballots that had already been cast but not yet counted. Is that a ruling for workers' rights, or is it actually suppression of workers who'd prefer more freedom in the workplace? Let's bring in Mark Mix. He is the president of the National Right to Work Foundation, who's been working on this case for several years. Mark, great to have you. Thanks for your time. Appreciate it.
Well, Tom, thanks for the opportunity to talk about it. You summed up things pretty well. This is an interesting story. It's kind of a man bites dog story when, union officials and congressmen like Andy Levin say we got to find ways to compel people to join unions and be associated with unions. Here we have a case where workers are trying to get out, and oh boy, not only do congressmen like Andy Levin and bureaucrats at the National Labor Relations Board, they don't want anything to do with workers trying to get out and exercise their rights under labor law. This is a perfect example of that.
It is. So let's start off. First off, what was the problem with these union officials in this case that the employees of this construction company want to remove them?
Well, it goes back to June of 2018 when the contract that covered these employees and a lot of other employees of construction companies in Michigan, there are a bunch of contractors that are under the same agreement that's negotiated, and it kind of applies to everyone. So in June 2018, we have a strike, and then, or June 28, the contract expires. In July of 2019, the union officials call the workers out on strike. The company is negotiating. They're negotiating with the union for a new contract, and there is a contract that's agreed to for a lot of construction companies, but this particular company had a problem with one of the issues as it related to subcontracting. And so the union calls a strike, and in March 2020, get this, we're over 2 years old, the employees gather together, and they get the requisite number of signatures to trigger a decertification election. Tom, you explained that really well. They could do that, and basically they've said, we want to remove the union from our workplace. We no longer want them to represent us. And I think it had a lot to do with the negotiations and the intimidation of workers saying that, hey, if they wanted to go to work and feed their families and cross the picket line, they were going to be fined up to, in some cases, $30,000 if they crossed the picket line. So in July, actually, the National Labor Relations Board during the Trump administration issued new rules about how decertification works. The old rule was if employees started filing decertifications, the unions would immediately file an unfair labor practice charge, which would block the election. And it didn't matter whether the unfair labor practice charge had anything to do with the issues that were relevant to the decertification. It just was file the charge, block the election, and here we go for a month, 2 months, 6 months, a year, or in this case, 2.5 years. Well, immediately after that NLRB decision, the workers filed another petition in August of 2020 to have the union decertified. And actually that election was processed, and the workers actually cast votes. And then, Tom, this won't surprise you, or maybe it will, and maybe you can show out more outrage than I'm going to explain here. But On November 9th, basically 6 days after the election, and this is really relevant, in 2020, November 9th, hours before the votes were going to be cast, the regional director in Detroit said, you know what, let's not count the votes. Let's go back in and litigate this and figure out if these ULPs have any substance. And, one thing happened on November 3rd, and that was that Joe Biden was elected. And what that signaled to the bureaucrats at the NLRB, who are very much in favor of forced unionism, hey, there's a new sheriff in town. We probably can get this done. And that's exactly what happened, Tom. The decertification petitions have been dismissed. The election votes have been impounded. We don't know where they are right now. We assume they're going to be thrown away because they'll never get to count them. And that's where these workers are fighting against, trying to get out of the union. Getting in is relatively easy. Getting out is extremely difficult.
Oh, it is very, very difficult. So let me ask you this very simple question. How does a union boss come in and say, yeah, we don't like this petition against us, so we're blocking it, and if you don't like it, too bad?
That's what the rules were prior to July of 2020 when the NLRB and the general counsel decided that, you know what, it's standard operating procedure for union officials to file ULPs no matter what the cause is. We actually won a case a while back on behalf of some workers at a company called St. Gobain's in Connecticut, where it said that in order for them to block an election, there had to be some kind of hearing that actually received testimony about what the issues were in the unfair labor practice charge. It's called a causal nexus. There had to be a causal nexus between the ULP and the decertification petition. In this case, the regional director in Detroit wouldn't even give them that so-called St. Gobain's hearing where the union had to prove that their actions trying to block the election had anything to do with the employees' decertification and not just, hey, they're trying to get out, file an unfair labor practice charge, let's block the election, we'll make it last for 2.5 years, and then finally, these employees who have no real legal representation and can't hire their own attorneys to do this type of work because they can't figure it out on their own, they just basically get tired and they say, okay, I guess we'll give up.
Yeah, no union steward is going to come around and help them in this because it would be antithetical to what the union would believe. Can you explain the Michigan right to work law? Because this was passed in late 2012. It went into full effect in March of 2013. And my understanding is that it basically says that if you join a union shop, you're hired by a union shop, you cannot be forced to pay union dues and you cannot be forced to join a union against your will. Is that the case?
That's right. It really is that simple, Tom. And here's what happened. Since 1963, in a case called General Motors versus NLRB, no one has been ever required to formally join a union. And unions will say that. Look, no one has to join the union. They just have to pay money to work. So in Michigan and 26 other states across the country, a worker can decide for themselves whether they want to financially support a labor union. They can't lose their job if they decide not to. The problem with that is there's still this forced association that exists in labor policy, and you explained it. They go into union shop. The union is the only people or the only person or the only individual, the only voice that the employer can talk to when it comes to terms and conditions of employment. So a worker that goes in there has to associate with a union. They give up their right to represent themselves. They give up their right to talk to their employer directly. But, before the right to work law in Michigan, they were forced to pay for that injustice by being forced to pay dues or fees to a union. So the right to work law is real simple. You decide whether or not you want to financially support a labor union in Michigan and 26 other states in the country.
We have 5 seconds left. Yes or no? Is it illegal to intimidate or threaten somebody into joining a union or paying dues?
Yes.
Okay. It can't be more clear than that. Wow. It's an intriguing case. People should really look into it. I'm glad that we got to talk about it this morning. Mark Mix is the president of the National Right to Work Foundation. You're doing good work, Mark, and I appreciate you joining us on WJR.
Thanks, Tom.
Thanks. Have a good one.